Ladies and gentlemen, we would like to remind you that the taking of photographs and use of recording equipment are strictly prohibited in the concert hall. Please take this moment now to silence your cell phones. Thank you.
Welcome to Law of the Land, the Supreme Court's Year in Law, our annual summer program that will take you inside the Supreme Court's major rulings. I'm Susan Engel, and I have the privilege of being the executive producer of 92nd Street Wide Talks. I'm delighted to have so many of you with us on this summer evening, those right in front of me, as well as those tuning in remotely from all across the world. I want to thank our valued partner, the Forum on Law, Culture, and Society, for co-producing tonight's very special program. Our esteemed moderator is Thane Rosenbaum. Thane is an essayist, novelist, and distinguished fellow at New York University School of Law, where he directs the Forum on Law, Culture, and Society. We are eager to have you, our audience members, participate in this discussion, so I invite you to write your questions on the note cards, and our ushers will pick them up midway through our program. If you are receiving CLE credit for this program, please remember to sign out at the end of the event. And now, I turn this over to Thane, who has moderated programs with us now for more than 20 years, and we're very grateful to have him with us this evening once again. Thank you, Thane.
Thank you, Susan. Are we on? Yes, excellent. Welcome, everyone, to the Forum on Law, Culture, and Society, wildly successful annual The Law of the Land, the Supreme Court year in review. If you've joined us before, we do a lot of different programs. We have a film series, we have a conversation series, we have something called Trials and Error. Kenji actually was once the subject of one of those. This is wildly successful for so many reasons, mostly because people don't see the Supreme Court. They're enormously curious about the Supreme Court, but it's sort of an opaque institution, and so we open it up for them. Now, if you've ever come to Law of the Land before, you know we sort of treat it like a game show. And I mean that seriously. We have two members of our conversation who are here every single year. They are two constitutional scholars, Kenji Yoshino, who's a professor at NYU Law School, Kenji Yoshino, and Trevor Morrison, who is the dean of NYU School of Law, Trevor Morrison. Now, the reason they don't rotate, we always have them every year, is because they kind of know the Constitution better than anybody. It's widely known that they're the only name you really need to know. Every year, professors from Harvard, Yale, they call me, they want on the program. I say, who do you think you are? Honestly, seriously, you're not Kenji, you're not Trevor. Treasure, I love that. That was a great slip. And, they complain, but, we got the best. And so, and it bothers them, but we have them and they're here. There's a sort of a little secret that not everyone knows about Trevor. Can I tell them?
Depends which secret.
All right. Trevor clerked for Justice Ginsburg before he started his career. And so if you hear him repeat the word Ginsburg like 70 times tonight, you'll probably know why. It's unbelievable. It's his favorite justice. It's like Oedipal for him. He has her baseball card at home. So then that's the group that never rotates, and you see them every single year because there's no one else worth seeing. Now, on the other side, we have sort of our celebrity game show contestants. These are the people who you see on television or read in the newspaper every year. Last year we had Adam Liptak from the New York Times. We had Nina Totenberg from NPR. And so we rotate them every year. So this year we have the lovely and distinguished Joan Biskupic, who you know from CNN. She's not only CNN's legal affairs correspondent and analyst, but she's also a biographer of two Supreme Court justices, Scalia and O'Connor. And she also wrote a book about the confirmation history of Sonia Sotomayor. And so in many ways, she's an interesting person to talk about the personalities of the Supreme Court, Joan Biskupic. And fresh off his star turn last week on Bill Maher's show, that's how we roll here.
This is your game show host.
Is someone whose face is always familiar. He's now the ABC's Legal Affairs national anchor, but for 15 years he was on NBC and MSNBC. I don't think there's a network you haven't been on as an anchor. Dan Abrams. Now, before we get to the discussion, there's actually only one other tradition that we have here that not everybody knows. In our celebrity group, one set of their parents always shows up. So last year, Adam Liptak's mom and dad was here. This year, it's Dan's mother and father are here. And I don't think this is a tradition we can actually, Dan's father is Floyd Abrams, the great First Amendment lawyer. You may not have known that connection. There he is. I can honestly say, I don't know if this is a tradition we can keep up for much longer, because like next year we're gonna have Jeff Toobin. I haven't quite said to him, Jeff, you kind of have to bring your parents. But for at least the last 2 years, it worked out that way. Let's get to the discussion. I would say, and I don't know if anyone will agree, it wasn't a great year for the Supreme Court in terms of the decisions that came down. There was no affirmative action case. There's none of that sort of abortion case, the kind of case that sort of rings politically true to us, that invigorates public discussion. Some of the more interesting cases are going to be actually decided next year, and we'll talk some of those. But I'll tell you what is interesting, and I'm sure the audience here and watching remotely wants to know, is Justice Gorsuch. And maybe I'll start with you, Dan. Tell us about that entire political process, the nomination experience. What are your reflections on the entire Gorsuch matter? And we'll open this up to others, but was that a stolen seat for Garland? I mean, this is going to have implications for decades, and we should spend some time talking about it.
So, on the question of Gorsuch, look, the bottom line is I think he is the type of candidate that any Republican president would have considered very seriously for the court. When you talk about qualified, right, which is such a loaded word, but qualified, meaning based on his history, his experience, his education, there's no question that he's qualified. And so I think that the issue for those of us, for example, in the media, as we were waiting to find out who was Trump going to nominate, I don't think there's ever been as much of a sense of we have no idea as when it happened in this case. And I say that because President Trump is such a wild card when it comes to these issues. There was no sense of, is he going to go mainstream? Is he going to go rogue? You just had no idea.
What would rogue have looked like?
His sister,
That was a shot at that.
Yeah, I mean,
She is a judge.
Yeah, she's a federal appeals court judge. That could have been, that would have been.
But he wouldn't do that because he's not interested in promoting his family.
Right, yeah.
That's just not going to happen.
Yeah. So look, I think that, and I'm sure we'll talk about this later, about other possible picks down the road. I mean, I think Pryor would be viewed from the 11th Circuit as a more radical pick than Gorsuch. But I think that what we've seen so far is that he has been a consistent and reliable conservative. And I mean that on every issue he's addressed, from guns to gay rights to every single case thus far that he's addressed. He has been either taking a position aligning himself with Justice Thomas as one of two, or has joined the majority. But I think that for those who voted for Donald Trump because of the Supreme Court, they should be very pleased. One of the things, though, that I find interesting, and I'll end on this note, which is when you think about the difference between conservatives and liberals when it comes to court appointments, what would have happened if Hillary Clinton had appointed Nina Pillard from the D.C. Circuit or Stephen Reinhart from the Ninth Circuit, who's now 86, so it's not likely. But my point is just a real, people who are viewed as real liberals. Because, you talk about it in the media, right, and people say, well, come on, Elena Kagan is a liberal, and Sonia Sotomayor is a liberal, and they are, comparatively, but they're not the left of the judicial philosophy on the court. And I would be, I don't think you'd ever get confirmed, ever, someone who is on this sort of the left, the far left of the spectrum, and yet on the right, the Gorsuches of the world get confirmed. It's an interesting dichotomy between the passion that conservatives have about the Supreme Court versus liberals.
Now, Mitch McConnell actually told President Obama, he says, Mr. President, you will not be able to fill this vacancy. It was almost a threat, saying it's not going to happen. You can bring Garland, but we will not get a vote on Garland. The interesting thing, and maybe Trevor or Kenji, you might want to speak to this, Garland, as I think Dan is suggesting, was a moderate, right? I mean, this is a guy who is not only so eminently qualified, but I think Obama knew what he was doing. He didn't want to antagonize. He said, look, I'm going to give you someone that you should like, you should be able to accept.
Let me remind
Sure.
people also about his age, given the difference. Neil Gorsuch is 49 years old. He will be there on the Supreme Court for your children and maybe your children's children down the road. Merrick Garland is 64. And that's a real difference here. And the president deliberately chose someone who he thought wouldn't prompt exactly what happened that fateful night, I think February 13th, when Antonin Scalia died, and Mitch McConnell got out there very boldly before anyone knew what was happening, really, and said, no way, no how, and got all his troops together.
But is this...
The point is very well taken.
But is this something that's also new? I mean, now we're just sort of expecting that a Supreme Court justice is going to be as young as possible for ideological reasons. I mean, Justice Cardozo, I think, was already a senior citizen, I think, at some point when he was appointed. I mean, at some point, we're going to take someone right out of law school who's ideologically...
We got a bunch of good ones.
Yeah, at NY. We have the 2 constitutional lawyers, and also from now on, all the Supreme Court justices will come out of NYU, too.
Yeah.
But then Clarence Thomas in 1991, he was just 43, I
42,
believe.
yeah.
So the Republicans, picking up a little bit from what Dan said about...
Joan, a little closer to
Oh, sorry. Republicans want them to be very committed, very tested, and very young. Antonin Scalia was just 50 when he was named. Sandra Day O'Connor was just about 50. But then think of Trevor's former boss, Ruth Bader Ginsburg. I think she was just about 60 when she was named. So you do have that gap there in terms of what these individuals are able to do to make their mark over time.
Do either of our constitutional scholars have a sense of what we always ask the question, what the Founding Fathers were thinking? What were the Founding Fathers thinking when they appointed John Jay? What did they want in a Supreme Court justice? Did they want someone ideological? Remember, there wasn't political parties, I suspect, at that time. I don't know how ideologically it was Federalists versus anti-Federalists, or youth, as an example. I mean, did they think of this, or is this something that the Republicans invented in the last 20 years?
Well, it's interesting that there is no age limit, right, or age bound for a judge, in the federal judiciary in the way that there are for elected representatives.
And you're saying that's all federal judges, not just Supreme Court justices.
Exactly. Any Article III judge, or really any judge, there's no age limit in the Constitution, right? So you have to be 25 to be a representative, or 30 to be a senator, or 35 to be a president under the Constitution. But for judges, it's open season. I think part of that is frankly because the Supreme Court was a much less prestigious institution. I think we really have to remember that back in the day. So it's not just the absence of political parties, and I think you're absolutely right about that. The Anti-Federalists and the Federalists were at war with each other, but it didn't have quite the overtone.
They didn't play it out in the court.
Exactly. Well, they did, but I just think that it's such a different. I think there's so many differences that we have to really dig down into the subtleties to get to how they might be similar and how they might be different. But I do think that's different in kind and not simply in degree from what we have today. But the Supreme Court also, and the federal judiciary in general, was not a really prestigious body. People always think that John Marshall was the first justice, but he actually was, quite far down the line, I think fourth, so that his predecessors would leave to go be diplomats or go to be state Supreme Court justices. So it's unimaginable today, right, that, say, Chief Justice Roberts would leave to go be a justice on the South Carolina Supreme Court instead of the United States Supreme Court. But that just shows you what a sort of tender and fragile body the Supreme Court was at its
So
founding.
I guess you're saying that this founding fathers would be surprised what happened, that it became so politicized and so important.
Well, start with important in a way. So the role of the court in modern American life has a whole lot to do with the role of the federal government in modern life in ways that are different. It's not to make them illegitimate or legitimate, but certainly different than was the case early on. And one can't think of that history without thinking of the Civil War, the causes of the Civil War, and the aftermath of it, the Reconstruction Amendments, which profoundly changed the relationship between the federal government and the states. And then the courts working out of the implications of the content of those amendments, including things like the Equal Protection Clause, brought the Supreme Court of the United States into direct confrontation with deeply problematic practices at the state and local governmental level in a way that had not been true for the first century of its existence, really. And that meant that the stakes, the potential stakes in some of the matters that the court would take up just went up astronomically. Not that there weren't deeply consequential cases in the court's history that Kenji and I teach early in its period, certainly during the Marshall Court. But the court was not in the business, really, of enforcing individual federal constitutional rights against state and local governments for the first century of its existence, really longer than that. That's the story of the last 100 years of the court. And so when the stakes go up, naturally the political contestation will go up as well, which is not to normalize or justify where we are now. I just wanted to add something. I think Dan made a very interesting point, just thinking about what's possible in a nomination of a new justice today. And I may well be right that anyone we would identify as a sort of leading member of the progressive wing of the courts of appeals today might well be unconfirmable in today's politics to the Supreme Court. Justice Ginsburg, there to start your count, has said that she believes that she couldn't be confirmed today, given her prior work with the ACLU, among other things. And what's interesting about that is it wasn't very long ago that conservatives thought it was precisely the opposite. So they took the defeat of Robert Bork's nomination as evidence that politics would not allow the confirmation of a true conservative. Now, I'm not a good candidate to reconstruct that argument in its best light. I don't know how one could make that argument given in the same basic time frame Antonin Scalia was confirmed to the Supreme Court. So it's not like real conservatives weren't being confirmed. But if one thinks about the politics of the Bork moment, among other things, it seemed like a shot across the conservative bow. You can go too far and we'll resist. But we seem to be in a very different political time today.
But I wonder, though, given what you said, whether the Democrats now regret the Bork fight, because it introduced something. There used to be a long-standing tradition to confirm in the Senate the president's choice. What did they say? The term of art is elections have consequences. I'm now the president, and I get to make my picks. And the Bork fight, here was a guy who was a former federal judge. He was a distinguished law professor. He, too, was phenomenally qualified. And yet I wonder whether, and I suspect the audience on this stage leans left, whether the audience on this stage wonders, yes, but he should have been rejected. And yet now we see this in reverse when it came to Garland.
Well, what it was, though, I don't think the Democrats would regret what they did.
Joan, a little closer.
But I think what would happen is that exactly what we saw. Republican nominees no longer were as forthcoming as Robert Bork. Robert Bork had that wonderful line about the intellectual feast, and he told us exactly how he felt in many ways. Flash forward to this year's hearings for Neil Gorsuch, where we didn't learn really anything new, and he shaded so much of what he had done before and what he would do on the court that we've already seen. But in some ways, who could blame him? His mission was to get through. And I would say that for Republicans, what has been in their minds as they've chosen people, not just Robert Bork, but David Souter. They have carefully vetted their appointees, and that happened with Samuel Alito, that happened with John Roberts, it will probably happen with the next appointee, and I think evidence of it is exactly what happened with Harriet Miers. When George W. Bush nominated Harriet Miers to be an Associate Justice in October of 2005, and the hard right rose up and said, no way. It was actually the hard right that went after her, and that's why her name was pulled back. So the theme that we've all struck on is that the Republicans, the conservatives, have taken this very seriously, and it has borne fruit.
Can I
Yeah,
just come in and say I totally agree with everything that Jonas said. I just wanted to riff on your earlier point about should progressives regret, what they did to Bork. And I said progressives might regret that. Progressives would be wrong, right, and regretting that. Because if you actually trace what happened, right, because Bork went down, then Douglas Ginsburg went down, and we got Justice Kennedy.
Right.
So, we have the luxury as progressives of fighting over Kennedy's vote in all of these cases until now, until he's replaced, right? In a way that we would not have had the luxury of, fighting over Bork's vote with regard to things like, same-sex marriage or any number of other issues, abortion, what have you, right? Affirmative action. So, I think that we have to understand that there's a kind of realpolitik here that we have to trace, and that sort of leads me to say, I think the thing that has many progressives sort of shaking in their boots right now is this notion that Justice Kennedy has told Nina Totenberg and David Latt that, or clerks people who are interviewing for his clerkships for the 2018 term have said that he has said to them that they might not have clerkships because he might be retired, right? And so I think that that's going to be, as we all know, that's going to be the real game changer on the court because a swap of Scalia for Gorsuch is not going to be that much of a distinction.
I want to follow up something Joan said. Before I do that, Kenji doesn't know that, but David Latt is out here. So that was cool for him. I'm sure that he loved that. That was a shout out for a journalist who's sitting out here. Where is he? There he is. How happy are you? So Joan said something that I hadn't thought about, which was how forthcoming Bork was. And it made me think about the Kagan nomination. Because there were people who said, remember, Justice Kagan started out like our friend Trevor. She was the dean of Harvard Law School, that school that can't...
She did some things before that.
Yeah, she did. That school that can't get anyone on this stage. Anyway, but there was some talk that there were things that she didn't write that she might have written, things that she might have said that she didn't say, because she had the kind of career that she thought, I might get appointed to the Supreme Court, and I wonder whether there's another consequence of Bork where super smart people decide not to write a law review article, because I don't want that law review article to come back at a Senate nomination. Is that, do you have a sense of that? Is there something the two of you aren't writing because you think you want to play this smart?
Nah.
Okay, all right, let's I thought that was a hell of a point. Elena Kagan grew up on the other side of the park. It was cool. Let's talk one more thing about Gorsuch. I do think he sort of hit the ground running, right? This is a guy, in June alone, he wrote 8 opinions. And let me just say, not only did he write an opinion, listen to this. I'm going to read to you from one of the opinions. They said that, I think Trevor reminded me that Justice Frankfurter once wrote a letter in which this is what you said, that Brandeis said, it took him 5 years. Justice Brandeis, there's a university named after that guy. Took him 5 years to figure out, how to get on, to do the Supreme Court, to do the work of the court. And Gorsuch is hearing none of that. He's sort of stepped in immediately, and he says, if a statute needs repair, there's a constitutionally prescribed way to do it. It's called legislation. To be sure, the demands of bicameralism and presentment are real, and the process can be protracted. But the difficulty of making new laws isn't some bug in the constitutional design. It's the point of the design, the better to preserve liberty. This guy thinks he's Cardozo.
You know what I was reminded of when you started talking about his record? During his testimony, he said, sometimes we judges do best when we do little, we don't do much, we do the least. Well, he sort of did the opposite. And folks have all sorts of speculation about the fact that he had come on roughly April 10th and he really wanted to do things. His clerks really wanted to have a piece of the action because they were going to be there briefly. But I have never, in my more than 25 years covering the court, seen a justice come on this forcefully in a way that rattles his colleagues. During one oral argument, he corrected the Chief Justice about where a certain highway was up in the Pacific Northwest, and then he had to say, oh, I was wrong. So there was some tension during oral arguments. He's been a bit admonishing of his colleagues in some of his dissents and concurrences. The Supreme Court is all about seniority and being overtly respectful for the brethren and sistren who came before you, and he doesn't quite have that. And he's kind of broken in a big way that I think that proves the adage that I'm sure just about everyone in this room heard during the 400 days that we were waiting for a new justice, Byron White's mantra that you change one justice, you change the whole court. And in this way, not only is Neil Gorsuch changing the court on the substance, but I think also in the dynamics among the justices, we're going to see it.
Dan, sorry, I wonder whether Gorsuch is taking a cue from the man who appointed him. President Trump saying, you don't have to, there's no decorum, I can tweet and insult you. The hell with you, Roberts. I can say whatever I want. Look at me.
My guess is that, look, when you look at what he's done, you would say, putting aside ideology and politics for a minute, one would say, this is good. This is good. He's jumping right in. He's not afraid. He's going to speak his mind. I'm sure that offends liberals, right? Because they're saying, oh, gosh, I wish he'd be quiet more. I wish he wouldn't get... So the bottom line is, this is what he was appointed for. And I do think that, look, I don't think it's a Trump issue. I think it's, a sort of a cultural issue. I mean, we see it in law firms leaving the lockstep. And, across the legal world, the idea of sort of looking up to one's elders and saying, oh, thou who is so great. The bottom line is, Neil Gorsuch, I'm sure, believes that he's earned this position, and he clearly has the confidence to, issue these opinions and take positions that are, at odds already with sometimes the majority, including some of his fellow conservatives on the court.
I think that's a very powerful and important point. Liberals, progressives have at other times taken what have struck me as somewhat cheap shots at other conservative members of the court when they've thought that they were just a junior partner with some other conservative in some larger jurisprudential project. And those were cheap shots because each member of the court is a fully fledged member of the court in his or her own right from the moment that they're confirmed. And we would think, or at least we should think, that there's something profoundly wrong if a justice feels that he or she is not allowed to take a position that they otherwise think is right simply because they're the new guy. That can't be the theory of a well-functioning court.
Even a young new guy.
On the other hand, and this justice, was a very distinguished Court of Appeals judge, served in the senior ranks of the Bush administration in the Justice Department, was a very successful and distinguished a partner in private law practice before that, clerked at the court, undoubtedly was a student of the court, clearly is a student of the law, and to his credit is willing, to be the kind of public servant who brings all of that to bear to do the job as he best can. On the other hand, in the writing of opinions or in the decision whether to write a concurring opinion that doesn't need to be written in order for your vote to be cast in the case, or to write an opinion just commenting on the court's decision whether to grant review in a case, which is really not the kind of opinion that has to be written, there's a certain level of discretion, and it is remarkable the number of times that this new justice has chosen to write technically unnecessary opinions, and then in those opinions sometimes to say things that are remarkable. It's not that it's not his right to do this. And it would be wrong, I think, to suggest that there's something contrary to the judicial role by his doing any of this. But if I were one of his colleagues, I think that I would have been surprised to read an opinion written by someone on the court barely long enough even to count it in months, that he concludes his opinion by saying something, and this is in a concurring opinion in a case where the majority opinion was written by Justice Kagan. It wasn't a close case in terms of the vote. And his criticism of the majority opinion was not as to its outcome, but that it had gone too far beyond what was strictly necessary to resolve the case. There was sort of additional commentary that he thought the court shouldn't be saying all of that now. It should be waiting for lower courts to weigh in on these issues, and the court can have the benefit of that learning. The final sentence in the opinion, he says, this court often speaks most wisely when it speaks last. Now that's a kind of witty line.
It's also a diss.
It's, well, maybe, yes, but it's also the kind of line that is powerful if it reflects experience.
Huh.
And the only experience it could reflect is the experience of an observer, not a justice on the court. And I was struck by that line in particular.
All right.
It might not be wrong, but it's also not modest.
Let's get to some of the cases. Let's start with the 2 travel ban cases. Now, those are important because they're actually going to be decided next year, next term. But these are the cases that essentially there was a 9th Circuit opinion and a 4th Circuit opinion that had adjoined President Trump's executive order banning Muslims from 6 countries, or banning people entrance to the United States from 6 Muslim countries.
Big difference.
Huge difference. Huge difference. 6 countries. It's not a Muslim ban. It's not a Muslim. I'm going to do my Alec Baldwin imitation any minute now. It's not a ban. So the Supreme Court essentially said that put back in partial effect the ban. And that this case will ultimately get decided, or just argued and decided before the Supreme Court next year. President Trump, of course, saw this as a huge victory, and it's really sort of it's sort of a partial reinstatement. But because there is, I think, a piece to this that says you can still enter from those 6 countries if you have a bona fide connection. So if you're a student, or if you have a job, or if you have a family member, you can still enter the country. I understand there were 3 Supreme Court justices that signed dissenting opinions that thought that even people with a bona fide connection should not be permitted, and I think Gorsuch was one of those. What do we think about this case? And I specifically want to talk about the thing that President Trump says all the time, and his Solicitor General will no doubt say before the court in oral argument. This is my job. I'm the President of the United States. I have a constitutional duty to protect the country. And this is what I'm doing. I'm protecting the country. These are dangerous 6 countries, and that's all I'm doing. This is what the Supremacy Clause entitles me to do. This is what the executive branch means. This is what it means. It's my constitutional duty. What's the response to that? What might we hear in that case? Kenji? Joe?
Sure. Go.
Well, I'll just say that the point about executive powers over national security is pretty strong, that I do think that part of the calculation of some of the lower courts that handled this might have been exactly how this administration did it within the first 7 days of coming into office. In fact, the lower court judges who assessed the travel ban and the 4th Circuit, when it, again, put it on hold, said, look, he comes in on January 20th, within 7 days, we have this, even though it was revised. So many statements that the president made reinforced the original idea that this was more or less a Muslim ban.
And the argument there is that it becomes a First Amendment issue.
Right, the idea that you're discriminating against people based on their religion. That's the core of what the 4th Circuit ruled. Now, the 9th Circuit that also allowed the ban to be put on hold ruled on statutory grounds.
Saying that it's an overreach,
Exactly.
that he'd gone too far
But
in the executive order.
nationality rather than religion. So this is a big deal for these lower courts to have allowed to put a hold on this, because as Thane suggested, the president usually has great power in this area, but I think we're in a different time. And I think what the Supreme Court was trying to do, obviously with the kind of ruling we saw, was sort of weave a very fine line to give Trump something, but not all. You know, he declared victory, but in some ways, I would think the challengers have a pretty strong claim to a victory here, depending on how this close relation terminology plays out below. And the only other thing I would mention, and I'm interested in Kenji's thoughts, is that it might not ever be decided by the Supreme Court thing. You know, because it's a 90-day clock ticking, that could run by the end of September, and they've said that they would schedule it for arguments in October, and it might be moot by then. So we'll just have to see how it plays out.
Yeah, exactly. So it's interesting about what the president would count to be a win, right? So if he says, you know, the clock ran out, it was mooted, so I ultimately scored a victory, that could be his way of delicately ushering this case out. But then if he wants to actually take the war to the Supreme Court, it's essentially going to be two hurdles that he's going to have to jump. And one is, you know, while the president has broad, you know, powers in foreign affairs, this is more Trevor's wheelhouse than mine, so I'll defer to him. You know, Congress under Article 1, Section 8 has plenary power for naturalization, so there's a separation of powers issue there vis-a-vis who really should hold the power, because as Joan was saying, there's a congressional provision that says you can't discriminate on the basis of national origin, and that's, you know, what we're doing in this context.
But what happens in a case like that?
And then
when there are two conflicting, right, pieces of the Constitution, I hate to say, does one trump the other? In this case, he's claiming, look, this is my national security obligation, and we're saying, well, Congress deals with these matters of naturalization, and that's what this is about. And so
in fact, there's even conflicting pieces of statute.
Yeah.
So the administration's main argument on the merits is, yes, this sort of general national security argument, which has a constitutional grounding, as you've described, but also has a statutory grounding, because the statute gives the president to designate countries and to foreclose the entry of nationals of those countries, or persons seeking entry from those countries, if he deems it necessary, and I don't have the precise language, but basically in the interest of national security. So there is also a statutory provision forbidding exclusion on the basis of religion. And so these two clauses, just on their face, are not easy to square, to put it mildly. The Ninth Circuit's decision, as Joan said, was a statutorily based decision. It's sort of a procedural statutory decision. What the court said there is that the Trump administration had not made a sufficient finding that national security required the exclusion of people seeking entry from these countries in order for it to be a permissible exercise of that statutory provision. The provision by itself does not require a formal finding, so I'll just say, like, that's it's maybe a plausible reading of that statute, but not a completely straightforward one. Whether you do this as a statutory matter or as a constitutional matter, if the court reaches the merits, there's going to be some challenge in trying to balance a concern about making sure the president is left with the power he needs, both statutorily and constitutionally, to address legitimate national security concerns, and that, as in other moments of heightened national security concern, that power doesn't translate into a kind of blank check. I think, you know, exactly how that balance will be struck is unclear.
And I think it's important to distinguish between the policy-related matters and the legal/constitutional. To me, the statutory ones, I think, are going to be, in my view, the more salient ones than the constitutional ones in this case. But, you know, no matter how much you hate the policy, it doesn't change the legal analysis. And when you said about the president's power, this will change his, it could end up changing her, depending on who the future presidents are. And so the danger of a Supreme Court ruling on this is that it will set precedent for obviously many years to come as to what the president's power is in this regard. And I think, again, when you're looking at it from a policy point of view, President Obama in 2011, it's pretty clear, at least stopped processing applications from Iraq for 6 months. People don't talk about that a whole lot. It's not about a right or wrong. It's just about the fact that the President of the United States in 2011 did that because he believed that there was a national security concern. Whether it was a ban or whether it was, they delayed processing, whatever the actual, however it manifested itself, it's important when thinking about this, because if there is a ruling which says one thing or the other as with regard to the president's power in this regard, it is going to be a very important ruling for presidents.
Look, that's a very important point, which is here, as it may well be, I think all of us on the stage at this time last year were talking about, so what will the court look like when Justice Garland is on it? So I'm reluctant to get in the prognostication business, but it's certainly possible that a consequence of the period we're in now is Supreme Court jurisprudence that is much more skeptical of presidential power than it had been before, that a consequence of the sort of assertions of presidential power that we're in the midst of seeing or that we might see could be, obviously one way is the court could endorse it or at least defer to it or sidestep it through mootness findings and the like, but if the court were to take it on and to do what the lower courts in the travel ban case have done, the loss will be felt more by later occupants of the White House, more because the jurisprudential legacy will endure. And so I think what that points to here is a deep and hard question. A whole lot of the court's doctrines when it comes to presidential power, not just in immigration, but across the board, are built on a sort of presumption of sound functioning of government. And it's very hard to read the lower court opinions in these travel ban cases as proceeding from that kind of presumption. They think that something has gone deeply awry. Now, they've then gone on to be very adventurous, taking tweets or campaign statements as evidence of governmental purpose animating an executive order is not something that I'm aware of a court ever having done before. It's not that it's not justifiable. Maybe it is, maybe it isn't.
We never had a tweeting president, though.
Right. My point is, I mean it to be separate from the justifiability of the position, just its novelty. And that novelty comes from, I think, the fact that judges are, like everyone else, trying to figure out what to make of a presidency that clearly is defying some conventional understandings of how power is exercised.
All right, let's take another case. This is actually one of my two favorite cases. This is the Trinity Lutheran case. This is the case that's out of Colorado. It derives from these Blaine amendments. I think I have this right. 39 states out of 50 have laws that prohibit the states to provide public funds for religious schools. This plays into the school voucher issue. So 39 states have these Blaine amendments, but in Colorado, the issue was one of these religious schools applied for—
I think it's Missouri.
Oh, Missouri, sorry, I keep saying it's Colorado, sorry, it's Missouri.
Colorado's the cake.
Right, cake. That's my second favorite case, and we're gonna, but that—
I feel like I'm playing Neil Gorsuch.
Yes, yeah, but you're the more distinguished one. It's totally different. In the Missouri case, in Trinity Lutheran, the religious school applied for $20,000 worth of public funds for the purposes of resurfacing their playground with tires, old tires. You see those now even in Central Park. They use old rubber tires to resurface. And was it Roberts, right? Justice Roberts in Trinity Lutheran said, look, this doesn't really violate the Establishment Clause. It's a public benefit that should be available to all students. And this is really a limited case, right? It's really just, it seemed he was saying, it's limited to the resurfacing of schools, your backyard. Now, I don't think the people that believe in school vouchers think that. They thought, wow, this just opens up an entirely new concept, right? That if you can pay for the resurfacing a playground, why in the back of a school, why can't you pay for school vouchers? So has this set a new dangerous precedent?
Well, Sonia Sotomayor, joined by Ruth Bader Ginsburg, certainly thinks so. In fact, Sonia Sotomayor used the occasion of her dissent this time to dissent orally from the bench. And as probably everyone here knows, justices usually don't do that. They do that if they want to call serious public attention to what has just happened. And what she said was that this is the first time the Supreme Court had allowed direct aid to a church group. Now, two other liberal members, Stephen Breyer and Elena Kagan, signed on to what the chief did. So, there's there's some nuance here about how big of a deal this was and the context involved here. And the chief obviously tried to have a compromise by writing in this footnote 3 that this is a narrow decision that involves only the public funds going on right here. The 3 more conservative members, again, Samuel Alito, Clarence Thomas, and Neil Gorsuch, said, this should have been more broadly cast. I think we'll have to see what happens in the states. I can't imagine that certain conservative religious groups aren't going to use it to try to push for more public funding. But I thought the dynamic was so interesting, even among those who signed the majority opinion. And this is a little bit of inside baseball, but it's about kind of the interesting personalities here. Elena Kagan joined the chief's decision in full. She did not break off at all to join Justice Breyer's concurrence, who said, look, I'm with the chief on this, but I just want to say that this is narrow. This isn't going as far as the dissent, my liberal colleagues would say. And I saw that move by Elena Kagan to be just the opposite of what Trevor observed about Neil Gorsuch. Elena Kagan is not going to break off just to break off. She wants to show solidarity for different things. In her first year, I think she wrote separately. I don't think she wrote separately from the liberals her first couple terms at all, because the message she's sending is, we're trying to work as a collegial group. We're trying to, find common ground. Whereas he's striking out again. It's exciting and suspenseful to watch, but I thought Trinity Lutheran was exhibit A for how the different justices are working with or without each other these days.
Another side note on Kagan, by the way, she went to middle school and high school 3 blocks from here. Could play into the school voucher program, but that was a public school. Anyway.
Yeah, just really quickly on footnote 3. Footnote 3 was not for a majority of the court, right? So, one way of reading it is that, Kagan or Kennedy, Linda Greenhouse has a great piece on Neil Gorsuch, actually, where she supposes, and we never know, but, where Kagan or Kennedy, inserted that footnote in order to limit this. I think in itself, that's a really interesting dynamic of this opinion is a ticket good only for one day. So it harkens back to Bush versus Gore, for example, of saying, this is really limited to its facts. You can't extrapolate this to other, contingencies or other fact patterns. But, clearly the conservatives jumped off of that. The 3 conservatives that Joan mentioned jumped off of that precisely to say, no, this is a broader matter of principle. So school vouchers are next.
It'll be it's an interesting question whether it's the thing that will be litigated, I suppose, whether it is cabinable to its facts. So this is grants. The grants from the state can only be used for a very particular purpose. I think it's literally for sort of renovating playgrounds through the use of recycled tires. It's not
pretty narrow.
Even generally renovating playgrounds is not enough. It's got to be very specific. And so the footnote, this is one of those cases where you have opinions. I join the opinion in full except for that footnote. The footnote does say we limit our consideration to something like funds for playground renovation, and we leave for consideration another day using state funds for religious purposes.
But isn't there also another case in New Mexico that's dealing with textbooks that I thought that's also either part of this term or going to be considered in the next term?
It could be.
Was that one of the ones that they granted, vacated, and remanded?
Yeah.
Yeah, there are several other state cases percolating up, and on the last day of the term, the justices sent back a handful of those with this device called grant, vacate, and remand, which means, tells the lower courts, you still iron it out based on what we just said. You figure out what we
But
just said.
textbooks is really that's beyond tires.
Sure, and so that will test the proposition whether the footnote describes a workable limiting proposition. So since becoming dean, I have to handle things like budgets, and that reveals something that someone who was me told there would be no math in this job, otherwise might not have known, which is money is pretty fungible, and so maybe I can only use the state grant to put the recycled tires in the playground. But if that means I have other dollars in my budget, I can use them for other things like religious purposes. And so it's quite unclear to me whether the limiting principle, of course, you can always say we just decide the facts in front of us, but at the level of principle, I'm not sure that the footnote's going to hold myself.
Kenji, I'm going to ask you about the 2 cases, one of which is, is my second favorite case. That's the Colorado case. That's Cake Master. Many of you may not know, we had Kenji as a guest for our Trials and Error series. He wrote what is clearly a definitive book on the Hollingsworth case. That's the Proposition 8 case that finally legalized, granted a constitutional right to same-sex marriage. It's a wonderful book. It's also a really wonderful read. And so there are 2 same-sex marriage type cases this term that were decided. One, I think, is being decided next term, but one is the Cake Master case, in which a Colorado baker is challenging the requirement that he would have to bake a cake for a same-sex marriage that he didn't want to honor. And he doesn't, and the idea is, I suspect the constitutional idea is that in order to promote equality, same-sex couples should be receiving the same service that a business is providing anyone else. If it's available to the general public, it should be available to them. And so I want my cake. Then there's the case, Pavin versus Smith, which is out of Arkansas. And this is the idea that these were 2 lesbian same-sex couples. And the idea here is that in Arkansas, they only permitted the birth mother to appear on the birth certificate and not the other parent, under some understanding that there's some biological reason it's only the birth mother. And of course, that seems to be inconsistent with Hollingsworth. So can you talk a little about those 2 cases, and then we'll join in, the rest of us.
Sure. So let me take them in reverse order, because one they actually decided, and then one is going to be argued, as you said, next term. So
the one they decided is Pavin.
Exactly. Yeah. So in the Arkansas case, what happened was that Arkansas has a legislative scheme that says that if you are married to somebody and that person is a woman and that woman has a child, then you are presumptively the father of that child. And then the Bergefell case in 2015, which made same-sex marriage the law of the land, also had language in it that said the constellation of benefits that attach to marriage will also be granted to same-sex couples.
And birth certificates was in it.
And listed birth and death certificates as examples of the constellation of benefits. So there didn't seem to be much daylight in between Obergefell and granting the same benefits to same-sex couples that were accorded to opposite-sex couples with regard to listing on someone on their birth certificate. The way in which the Arkansas Supreme Court sort of underruled, in a sense, Obergefell was to say that, as you intimated, Thane, that the real motivation here behind the statutory scheme was biological, and so that, and it's actually, on its face, quite plausible of saying, like, what we want on the birth certificate is a kind of Ancestry.com kind of genealogy, so that if I have a genetic disorder, I can go back through my birth certificate and figure out, where the genetic disorder might have come from, so that, I can discern various, things about my own family tree. The problem with this is that, Trevor talked about presumptions earlier, and the law is obviously rife with presumptions. It would be hard to even think about doing law without presumptions. And there's a presumption of legitimacy in Arkansas law that says if you are married to somebody, then that is the person's father, right? So even if in the classic kind of common law scenario where, a woman marries a man, the man goes off and sails the 7 seas for 7 years and could not possibly be the biological father of the child, if she's married to him and she has a child, out of wedlock, and he returns, he's the father, right? And so that's a presumption of legitimacy. So if the presumption of legitimacy is there, that means that marriage, the social relationship, is more important than the biological relationship. That is exactly what that presumption stands for. So it's really hard, simply because we're moving over to the same sex as opposed to the opposite sex context, that you would say that,
all of a sudden, this becomes more important.
Social relationships don't trump biology, right?
But isn't the key in the Cake case and the difference is that in that case it's about someone else taking action, right? Because up to this point, it seems the 2 Supreme Court cases have been about, the way that the government recognizes same-sex marriage, right? Or the partner of someone, et cetera. In this case, it's, it does present a new competing interest, right?
I think that's dead right.
Right.
And I think what made me agog, Dan, about the Paven case was that Obergefell seemed to just say in words of one syllable, these kinds of cases are covered by our holding, and nonetheless, right, there were 3 dissenters from the Supreme Court's denial or reversal of the Arkansas ruling on this case. And again, it was Justice Gorsuch who wrote that, saying that Obergefell was unclear about this, whereas I think Obergefell was quite clear about it. But to this point, I mean, with the Masterpiece Bake Shop case, what is at issue there are Colorado bakers who are covered under a Colorado non-discrimination statute. This is, you can't discriminate on the basis of sexual orientation if you're a public accommodation like a shop that is open to all comers. And
And this comes up with photographers. There have been cases like
Exactly,
photographers similarly to photograph a wedding.
That's
say,
exactly
I don't
right.
want to work that.
Photographers, florists.
Florists,
Yeah,
right.
yeah. And those 2 cases actually have gone against the photographer and the florist respectively, and then the Supreme Court has denied cert. So what's different about this case is the Supreme Court has actually granted cert
Right.
and it said we're ready to grapple with this issue now. And as Dan was saying, here it's not, here's a precedent, just interpret it. It's, this is actually unsettled law as to what happens when there are competing interests, where they're saying we have both free exercise rights and free speech rights against this public accommodation statute.
No,
Just to underscore the difference in posture there, what's happened in the cake case, it's not so much an assertion of a constitutional right by the gay couple to have a baker bake them a cake. It's that Colorado has decided as a matter of its non-discrimination law, and clearly states have the authority, the general authority, to enact non-discrimination laws, that discrimination on the basis of sexual orientation is not going to be a tolerated form of discrimination. They've made that legislative decision, and the question is whether in making that legislative decision, not the constitutional rights of the gay couple have been implicated, but the constitutional rights of the baker have been infringed. And so we've seen that shape of case before, but the constitutional right that will be argued about is not a right of the couple, it's a right of the baker.
why? Because his argument is, you are forcing me to choose between my religious freedom, liberty, and my livelihood.
Right.
That's it, and I think we're going to start seeing a lot more religiously tinged cases coming in the direction of the Supreme Court, given the new makeup of the court and just modern society and some of the dilemmas we've been talking about tonight.
Well, and similarly, in the Missouri case in Trinity, it was the state constitution there, right, which had similarly prohibited the use of federal funds.
Exactly right.
Yeah, or
To
state
avoid
funds.
An
State,
establishment clause.
It was
Right.
It was an objection to that state
Problem, yeah.
restriction.
yeah.
So that statute also distinguishes the idea that the Supreme Court has spoken that you can't discriminate on, lost my point. Come to me in a second, sorry. Go ahead.
Kenji was drawing a distinction earlier, not to, Kenji can more than ably speak for himself, but there is a clear difference
now.
between the Arkansas and the Colorado case on this ground, in the sense that one does seem fully covered by Obergefell and not the other. Right?
Exactly,
Right.
right, yeah. So I think that what we're dealing with in this case, I mean, to go back also to Dan's point about how this is just a state statute, when we think about the Civil Rights Act of 1964, which was our landmark, Civil Rights Act, one of the crown jewels of the civil rights movement, there were religious objections to that. So I think we forget that there were, these kind of religious right to discriminate cases, to put it slightly tendentiously, are not new. So when the Civil Rights Act of 1964 was enacted, Title II covers public accommodations. There was a barbecue joint that said, we don't want to serve African-American patrons because we have religious objections to any kind of integration among the races. So there are kind of precedents for this, in earlier jurisprudence. The question is whether or not the court will look at sexual orientation as being similar to race, right? And non-discrimination on the basis of sexual orientation as being a compelling governmental interest, as it has held that it is in the race context.
I have remembered my question before about the idea of the Supreme Court's already ruled, I think in 2015 or 2014, that businesses could not be forced to provide contraceptives, right?
So that's a Hobby Lobby case, right?
So that's a Hobby Lobby case. So will that case come up here, or is it distinguished by what Trevor said, that this is really about the discrimination statute within the
So
state?
to what Joan said earlier, like, it will come up, but not in this case. So I think one of the common kind of misapprehensions about this case is that it's going to raise the Religious Freedom Restoration Act kind of issue, and it won't for two reasons.
Which is
One-
what Hobby Lobby is.
Which is what Hobby Lobby is. So Hobby Lobby is the Religious Freedom Restoration Act, the Federal Religious Freedom Restoration Act. And that does not apply, for reasons that are too boring to go into here, to the states because of a 1997 case called Bernie versus City of Flores. So that's out the window. So this is not on all fours with Hobby Lobby. So the point
So
one.
you're saying it'll come up, but it won't be in any
Yeah,
way
but
dispositive.
point two is that many of the states have enacted, I think about a third of the states have enacted their own versions of RFRAs, mini RFRAs as they're known, but Colorado is not one of them. So there is no, right, statutory, this is not statute against statute, right? This is federal free exercise clause versus this public accommodation statutes, and then First Amendment free speech claims about expression and compelled expression in particular against public accommodation. I think that the free exercise clause, be interested to hear what my colleagues think, is borders on the frivolous, because the whole point of the Religious Freedom Restoration Act in 1993 is that the Supreme Court said in 1990 in a case called Smith that if you have a law of general applicability, that doesn't violate the free exercise clause. In other words, if you have a law that applies to everybody and it was not enacted with religious animus in mind, then that is only going to be subjected to the lowest form of constitutional scrutiny and is very, very likely to be upheld, right? So no one is saying that this public accommodation law in Colorado was enacted in order to persecute, right, Christian bakers, right? And so it's very hard to make that claim, right, under the free exercise clause, which is why RFRA was needed in the first place. But again, the federal RFRA doesn't apply to Colorado. Colorado doesn't have its own RFRA.
But you can understand how people see this in a much more simplistic way, to say, well, look, you can't force a business to provide contraceptives, but you can force a baker to bake a cake.
Right.
Right.
Well, I think that's more, and I'm slightly abashed to be talking about this with Floyd Abrams in the audience, but like I think that's where you get into the speech claim,
Right.
And so I think that that's going to be I'm not saying that it's the strongest claim, but I am saying that the religious claim has not been fully teed up yet in this case, right? So that will wait for another day. So what they're arguing there is that this is compelled expression, that there's artistry that goes into making a cake, and the same way there's artistry that goes into making a photograph. And so therefore, you should there are cases like the Woolley case, which is, you can't force a Jehovah's Witness to put live free or die, on their license plate, that they deserve an accommodation or an exemption from that because the government can't put words in your mouth.
But that's an interesting distinction, and I want to get to another case, but you did raise something that I was thinking about when I was reading about this, which is that this artisan argument. If I'm pumping gas and I'm offering it to the public, I can make a distinction because I'm just pumping gas. But if I'm baking a cake that deals with my expression because I'm an artist, I'm held to a different standard. Or I can invoke a new standard that Floyd Abrams could explain. It's an expression argument. Pumping gas doesn't quite have that. Aside from the elitist argument, it is hard to accept that I'm being punished precisely because I make a great cake.
Yeah, but I think that the best answer to that, I think there's several, but I think the best answer to that is what the one that the Colorado Court of Appeals gave, which was to say that, and actually I'm a little bit parti pris on this because I was a plaintiff in this case and lost this case in the Supreme Court, which was the FAIR litigation around military recruiting on law school campuses, right? And what the court said in rejecting our claim was to say, if you're required to do something under a federal statute, which we were under this thing called the Solomon Amendment, people can distinguish between people that you're sponsoring on campus and people that you're having at sufferance because you're complying with the law. Right, so it's sort of like, revenge of, my failed suit in order to say, right, that distinction, right, was deployed by the Colorado Court of Appeals, which was, affirmed by the Colorado Supreme Court as the distinction of like, if Masterpiece Cake Shop, says, we are doing this, right, is someone really going to mistake, right, their baking the cake for anything other than compliance with the Colorado anti-discrimination statute, especially if they are allowed to post things in their store that say we are, required to do under Colorado law, we are required to not discriminate on X, Y, and Z bases.
So before we take some questions from the audience, I want to make sure we get to two other cases. So let's try to do them quickly. Trevor, I'm going to turn to you, the partisan political gerrymandering case. This is the Wisconsin case.
Sure.
We all know that racial gerrymandering, this idea of carving up maps in order to create this unrepresentative districts, is unconstitutional. But we've never really seen this before in the context of political gerrymandering. I think it's in 2010, the Republicans of Wisconsin won the state house. They redrew the districts, and now everyone in Wisconsin who wins any position is a Republican. And so, this is a new concept for us.
Well, if the court, in this case, it's Gill against Woodford, so this is in the category, we've been talking some about cases the court decided last term and some about things on the court's docket for the coming term. This is on the docket for the coming term. And right, it's just as you say, the question is the question of partisan gerrymandering. And also, just as you say, Thane, there's a quite well-developed case law that the court has generated over many years with regard to race-based gerrymandering, if race is certainly the predominant factor driving decisions with respect to how to redraw an electoral map, then that states an unconstitutional purpose, and if the map is the result of that unconstitutional purpose, then in effect too it's unconstitutional. Now this happens, right? There are questions about this that arise with some regularity because each time we have the decennial census, that produces a different picture of the population within each state, and so the requirement of one person, one vote then therefore means that the maps need to be redrawn in order to achieve one person, one vote, basic electoral voting power parity from district to district. And so it's the question is the 2010 map, but it's not, just as you say, it's not a question of racial or race-based gerrymandering, but of partisan gerrymandering. There's another litigation going on in North Carolina right now that in some ways illustrates what we're looking at in some of these jurisdictions. The unconstitutionality of race-based gerrymandering is so clear, and the complete lack of any doctrine addressing gerrymandering for political partisan advantage, the complete underdevelopment of that doctrine, has led state legislators to say things like, I want to be perfectly clear. Race played no role in the drawing of this map. The only thing we cared about was maximizing the political advantage for our party, and we did that in this map. Like, you've got statements, that's in the North Carolina case, rough paraphrase, not the Wisconsin one. But the question, ever since, I want to say 2004, but it's really earlier. The last time the Supreme Court weighed in on this was a Pennsylvania case called Veith in 2004, which divided the court effectively in a familiar way, kind of 4-1-4. Four members of the court were prepared to say, this is politics, and there aren't legal standards that the court can craft for when partisanship is permissibly present and when it's impermissibly present. We ought to call this, for want of a judicially discoverable and manageable standard, we ought to call this a political question and just never intervene. We're not going to uphold plans, we're not going to strike them down, we're just not going to review them for partisan gerrymandering purposes. Four members of the court were prepared to say, oh yes, this does state a claim, and we can imagine standards that ought to apply, that ought to operationalize some understanding of what excessive partisanship would be. Justice Kennedy was in the middle, and he said, I don't think there's a standard today, but I'm not saying it's impossible to generate a standard. And so I'll leave open the possibility that in some future case, a workable, judicially discoverable, and manageable standard can be brought forward. The question in this case is whether the challengers to this plan have pulled that off. And the three-judge court below concluded yes. And now there is a standard that in many ways relies on scholarship from some political scientists, also a law professor at University of Chicago, Nick Stephanopoulos, is owed a lot of the credit for the work here as well. And the big question is, will a majority of the court be persuaded that in fact there is a justiciable standard here? And we'll have to see. The standard, I can give you just two more sentences. The standard that the lower court embraced is a notion of partisan symmetry, that you care about whether there was a sort of political partisan intent. In these cases, that doesn't tend to be a question. As I say, you often have legislators basically confessing it. But then was there an effect in the map that was drawn? And does the state have any sort of nonpartisan justification for the map that they drew? The big question is, well, how can you tell what is an impermissible partisan effect? It can't be the case that you can't think at all about politics. At least the court doesn't seem prepared to accept that notion. So what's too much? Well, we have measures from the literature, partisan bias, efficiency gap, that try to measure the extent to which the votes of one party or another have been wasted because they've been either cracked among multiple districts, so they lose all of them, but just barely, or they've been packed just into one district, which they'll always win, but they can't win any other districts. And if you win by more than one vote, you effectively have wasted a bunch of those votes. These are political science terms, and there are studies undergirding each one of them. I think the question is whether the Supreme Court thinks any of that amounts to constitutional law.
Dan?
Very quickly, I just want to say, I think this is the most important case for the next term that the court has agreed to hear, because I think that some of the effect of this could be, while some of the legislators are being overt about their political motivations, I think if the court were to say that political gerrymandering is constitutional, that there isn't a reason that the Supreme Court is going to step in and prevent it, it will be emboldening, I think, legislatures around the country, even more so, to say that it's not just something that's okay, it's something that is part of what's expected and what we do. It happens a lot already. We see it.
I think we're there.
But I think
it could get worse.
I think it could get. I think it could absolutely get worse from a sort of from a policy point of view. And look, and it used to benefit. There've been a lot of cases where it benefited Democrats, the gerrymandering, and it so happens in this case that the gerrymandering benefited Republicans. And these days there are more Republican-dominated state legislatures, and as a result, they would benefit more. But the pendulum swings.
I was just going to add that Trevor mentioned that we'll have to see what the court thinks. We'll have to see what Anthony Kennedy thinks, because I think he's been observing exactly what Dan is talking about here, and so much has changed since 2004 that there's plenty of evidence there if he's going to seize it, and that's why everyone was so concerned. Is Anthony Kennedy going to stay or go? And now we know, at least health willing, he will be here through the end of next term when they do decide that.
And just to add to that, the Veith case in 2004, Justice Scalia was in the writer who wrote the plurality opinion, said that there isn't a judicially manageable standard. The question I often get from my students when I'm talking about this is, how can you take any provision and then, isn't Scalia right? Because how can you take any sort of legal provision and then assign a point value as you would have to, almost a mathematical value as you would have to with the sufficiency gap notion? And what I ask them is this, is to say, is this more like something that we would think of as the heart of the political question doctrine, which doesn't mean is something a hot-button political issue, but rather is something better left to the political branches to decide, and not the judiciary, which is unelected and not accountable to the polity to decide. And the classic example that the court has taken up, from my perspective, on the lack of a judicially manageable standard is, how many years can an amendment be on the books before it lapses? And there the court would really just have to, if the legislature were silent, if Congress had been silent when it sent out the amendment for ratification, would really have to pull a number out of its ears and would have to say oh, it's 5 years or 7 years or 25 years or 100 years, right? And so there I think the court was quite right to stay its hand. But in other contexts, the court has interpreted very vague language, like the due process clause, to think about punitive damages, and has actually assigned mathematical formulas for how much can be awarded in punitive damages, and has cabined the relief that litigant can get in that domain. And I would say this is way on the punitive damages side of the spectrum. So unfortunately, Kennedy was in the dissent in a racial gerrymandering case this term, and so that might not bode well for this forthcoming Whitman case, right? But yeah. But I think it's at least on the, is there a justiciable standard on this? It's way closer to the punitive damages side of the spectrum than it is to the how many years can an amendment be in the books before it lapses.
Yeah, it can't be right that just because the court would have to come up with some kind of numerical threshold, that numerical thresholds are just contrary to the way courts decide cases. That's got to be right. I just wanted, I think what Dan said is very important, and I don't disagree with the stakes here, even if it's the case that sort of the pursuit of partisan advantage through the redrawing of electoral maps is rampant. those of us who've seen Spinal Tap, we could always turn it to 11. It could get worse. But the thing about the shoe being on the other foot, and there was a time when a certain number of the sort of use of partisan advantage in redistricting was by Democratic majority state houses, is true. But a striking thing about the present moment that I think is rather tragic is that there is a supermajority of state houses controlled by Republican majorities now, in a way that the kind of political understanding of this issue is coding itself as a partisan issue. So something that is really vexing about this case or even litigation in this area is that it often has the feeling of the Democrats arguing against partisan gerrymandering and the Republicans arguing that this isn't something that the court has any business being involved in. And that is tragic. Because it's true what Dan says.
But isn't that a typical states' rights versus not debate that one might have between Republicans and Democrats?
Well, that we could have a longer conversation about whether federalism is almost always a stalking horse for some other set of values. But here, it would be nice if the court were taking up this issue at a time when some state legislatures were engaged in partisan gerrymandering for Democratic Party advantage and some others were for Republican advantage. Because the threat to democracy through excessive partisanship in electoral map redrawing, this is where you're absolutely right. It can't be overstated. And it's so deep and profound that if the court doesn't get involved, we likely will not see the shoe ever being on the other foot. The success in electoral map redrawing through computer-generated computer-aided map drawing efforts is such that the majorities that are in the state houses at this point might as well be treated as permanent.
The political gerrymandering case was very hard to do quickly. That's what that's what I've learned from tonight. That was a hard one. So let's do one more, and then we'll take a question or two from the audience and say goodnight to everybody. If I don't forget before, for your CLE credit, make sure you check out the table on the way out. You've got to be able to check out it before you get your credit. Ziegler versus Abbasi. Another interesting case, and it's got very local implications. This is the post-9/11 civil lawsuits brought by Muslims in Brooklyn who were swept up in essentially a dragnet in the first couple years after 9/11. Many of them had immigration violations of some kind, but there was no evidence that they were suspects for any terrorism claim. They were taken and detained in Manhattan Detention Center, right near the courthouse, right over the Brooklyn Bridge. Many of them were physically not tortured, but abused in some way. There was humiliation. So they brought a civil lawsuit, and Justice Kennedy essentially the court essentially dismissed the lawsuit, saying that civil lawsuits are not the way to resolve these misconduct cases when you're dealing with issues, again, of national security, national defense. Interestingly, Justice Ginsburg and Justice Breyer wrote a joint dissent in which they wanted to remind the court and the world about things like, the detention of Japanese American Americans in World War II, and the suspension of habeas corpus by President Lincoln during the Civil War, and the Alien and Sedition Act, as if to say, this kind of civil lawsuit could be useful to put a check on executive abuses or executive misconduct. 9/11, it means a lot to people in this city. Does anyone have any strong feelings about this case? Is that rightly decided, or do you think the civil lawsuit should have been able to proceed?
Well, a case like this, you can think about a case like this on two levels. In an important but narrower level, this is a continuation of a trend that's now a number of years old, of the court cutting back in different ways on the availability of civil lawsuits for money damages to seek for redress for constitutional violations. The area of law that governs this when you're suing a federal officer is called Bivens. That's the name of a case, and it's really a judicially implied remedy, and it tracks more or less a statute that Congress passed that works if you're suing a state officer, 1983, and the court has sort of implied a remedy that parallels it for suits against federal officers. And for a number of years now, really decades, it's been in mostly gradual, but then sometimes bigger leaps, phase of kind of cutting back on that. The high water mark of the Bivens doctrine was over 30 years ago now. Now that's not to justify or to condemn it, but it's to make the decision not terribly surprising. At a higher level of generality, this is a case that raises a question about the role of the judiciary in policing the actions of the other branches of government. And if you think of it that way, there are other cases we've talked about tonight that are in that category too. The travel ban case is in that category too. Very different posture of case, very different kind of remedy. And maybe in this case, as in that case, the underlying theme is one about to what extent does the court think it's appropriate to assume that government is functioning more or less as it should. If the court continues to retain that presumption as a strong organizing way that it thinks about its job, then I think in the Bivens area, whether one is pleased or displeased by it, there will continue to be cases like this where the court is very reluctant to extend the availability of this kind of judicially supplied remedy for redress. If it starts to weaken in its belief that the presumption of regularity in terms of how government operates accurately describes how government is going, then a whole lot is on the table.
You know, we saw a consequence of that immediately involving, in a case that involved what we've referred to as a cross-border shooting, where a 17-year-old boy was shot by a border agent of the U.S., but he was on the Mexican side. And that case had been pending and had been a very closely watched case. The justices got rid of that case by remanding it in light of this Ziegler case that essentially closes the courthouse doors. You know, we'll have to see what the lower court does, but the signal that Justice Breyer at least took from it was that this family of this 15-year-old who was killed is going to be out of luck.
All right, let's take this question from the audience, and maybe, Joan, you can take part of this answer as well, because, you know, you are a Supreme Court biographer. And so the personalities and the dynamics on the court mean a lot to you, and you observe this, the interaction among the justices. This is from the audience. Based on the number of appointments that Trump will have, or expected to have, how do you see the court in 4 years? Now, you can answer it both ways. One is a direct answer, what we think it'll look like in 4 years, and then what it looks like now and what will continue to look like given the dynamic of the court as was presently constituted.
Well, I think this is one that everybody probably has some sentiment about, but I think already we know that if Neil Gorsuch continues to vote and write the way he has just in these short months, he might even be to the right of Antonin Scalia in a couple things. So that would obviously tip the balance over that way. And also, he's giving kind of camaraderie to two justices who had seemed a little bit marginalized, Justices Alito and Thomas, and he's fortifying them, and that's, I think, important in terms of the balance of power on the court. So let's say that Donald Trump picks another person who ends up being like Neil Gorsuch. Again, it will tip the court that way, but you never know. You never know. He could pick someone who he thinks is going to be just like Neil Gorsuch, and it will be actually like David Souter. We don't know, and it varies a lot. But let's just say, for purposes of argument, that he picks on his short list that's been so vetted by folks from the Heritage Foundation and the Federalist Society. He picks someone who's a tried and true conservative, young, committed, tested. Then I think what we're seeing is a continuing of the narrowing of judicial authority over rights, closing of courthouse doors. And again, it's based on the philosophy, for better or for worse, that it's the legislative branches who should be solving the problems out there. There'll be, so I think in terms of individual rights, there'll be consequences there. But there's always a reaction formation up at the court. It somehow steadies itself somehow, too.
Gentlemen? Well, but we don't have to answer it.
The only thing that comes to mind, and you know, it's a personal obsession of mine because of my last book, but is I keep thinking back to Chief Justice Roberts' dissent in the Bergefell case, where he compares it to Lochner and Dred Scott, and I was like, this just seems like gratuitously hyperbolic, right? But if you're actually planting time bombs, right, it's actually a wonderful time bomb for him to plant to say, back in the day, I compared the same-sex marriage decision to Lochner and Dred Scott, which are obviously two of the most reviled and rightfully overruled, right, Supreme Court opinions. And so there are, commentators who say that if there's another Justice Mark Joseph Stern on Slate and was talking about this, of if the chipping away of same-sex marriage, if not overruling it entirely, but sort of chipping away at the margins in the way that Roe versus Wade was chipped away at, so that the constellation of benefits disappears. That's one place to look. I think another place to look, we haven't talked about the Second Amendment at all, but the Second Amendment, the Supreme Court denied cert in the Peruta case, which came out of the Ninth Circuit, and was about whether or not you could do concealed carry, right, in a state that barred, open carry under the two Second Amendment precedents of Heller and McDonald in 2008 and 2010, respectively. And the Supreme Court denied review of that case, but then Justice Thomas and, again, Justice Gorsuch in dissent dissented for the denial of certiorari and said that it was inexcusable that the Supreme Court was letting so much time lapse without lending more clarity to the metes and bounds of the Second Amendment right.
Bottom line, most people think that there'll be, I think if you look at the numbers, that, by 2020, President Trump will likely have had 2 more Supreme Court picks, and 2 picks that will fundamentally change the court. This won't be a Scalia for Gorsuch. And, that's pure guesswork, but if you're a gambling person, that's what you would bet. That's the odds-on bet, is that he'll get certainly 1 and very likely 2.
The Forum on Law, Culture, and Society has programs throughout the year here at the 92nd Street Y and at NYU School of Law. Please check out our programs on folcs.org, folcs.org. Sign up for our email list. It goes out throughout the year. We hope to see you at a number of our events. Our night comes to an end. It was a stimulating night, fascinating and entertaining. Please thank Kenji Yoshino, Joan Biskupik, Dan Abrams, and Trevor Morrison. Good night, everyone. We'll see you next year for Law of the Land.